Hello again, Charles Cowap here. This is the fourth of our four presentations on planning blight and compulsory purchase, and in particular its impact on farmland and rural estates. In the first three classes we looked at what counts as blight and who qualifies for blight protection. In the second presentation we looked at the procedures behind the successful service of a blight notice, and in the third presentation we looked at the special position of farms. In this, the final of the four presentations, we're going to look at discretionary blight, and we're also going to consider a little update on HS2, the high-speed rail project. If you've not already had a look at the first two presentations, it would be well worth doing so before looking at this presentation. You can probably skip presentation number 3 if your interest is more in discretionary blight generally. Discretionary blight then is a much more vague area than statutory blight. Discretionary blight provisions can be found all over the place, but there's some in the Highways Act, there are some in the Planning and Compensation Act 2004, and the Land Compensation Act 1973 had some as well. Basically what discretionary blight provisions cover is land which lies slightly outside, or land which does lie outside, the scope of statutory blight. In other words, land which is going to be affected adversely by the carrying out of public works, but which is not actually required for those works. So, as it says on the screen, land which is seriously affected by carrying out public works, or land for the mitigation of the adverse effects of public works, and discretionary blight provisions come into play from the time that proposals are first. It really needs to be emphasised that discretionary blight is a discretionary power. I suppose it's what the name is on the tin. There is very limited guidance in most cases as to when discretion will be exercised in your favour. Sir Christopher Chope, then Minister of Transport, issued guidance in the early 1990s on the situation in which discretionary blight powers would be exercised by the then Department of Transport in relation to public road proposals, setting out that where blight by proximity arose because your property was within 100 metres of the centre line of a proposed road and you had made reasonable efforts to sell, then the department would seriously consider buying your property from you. They defined for this purpose reasonable efforts to sell as being on the market for 20 weeks and no offers within 5% of the market value. There were also specific reasons for which you had to be moving, for instance to move to a new job, to care for dependent relatives and so on. And the qualifying interests which the Department of Transport would be happy to consider were exactly those as for statutory blight. So owner-occupiers, resident owner-occupiers of houses, owner-occupiers of business property up to a rateable value threshold, and owner-occupiers of farmland as well. Anybody outside those areas would not be considered for the benefit of discretionary blight powers, according to the Minister's parliamentary answer all those years ago. Various schemes now have also introduced their own variety of discretionary blight scheme, but it's important to see these in the legal context of being, in the most cases, variations on discretionary blight. The most prominent example currently is High Speed 2, the high-speed rail link, where Phase 1 is linking London with Birmingham, and Phase 2 will go on to link Birmingham with Manchester and the North East. So Phase 2 has had an exceptional hardship compensation scheme announced, for example, last year, and Phase 2 is very likely coming to a home near you. I live in Nantwich in South Cheshire, and there's an extract from the plans for HS2 showing how the line is going to run into Crewe Station, not far from where I live. There it is, making its way through North Cheshire as well. So, would you be eligible under the exceptional hardship scheme for HS2? First of all, you need to be the owner-occupier of private residential property, the owner-occupier of business premises with a rateable value up to £34,800, the owner-occupier of an agricultural unit. Pretty much exactly the same definitions as we've seen for statutory blight in the earlier presentation. Mortgages in possession, however, also count, and personal representatives of people who are dead also count if the deceased person themselves had a qualifying interest as outlined in the first three of the bullet points on this screen. The criteria then to qualify under the exceptional hardship scheme are that you had the right type of property and the proper rights therein of the sort that we've just seen. The location. You must be close to the route and be likely to be adversely affected, but not over any of the tunnel sections. Efforts to sell must have involved your property being on the market for 3 months and receiving no offers within 15% of a realistic asking price. Fourthly, you must have had no prior knowledge of Phase 2 when you bought the property, and fifthly, you must be facing exceptional hardship. If we look at some statistics on Phase 1's exceptional hardship scheme, reminding ourselves there of what the exceptional hardship criteria were: property type and interest, number 1, location of property, efforts to sell and the impact of blight, and no prior knowledge of HS2 and exceptional hardship number 2, we can see that looking at exceptional hardship, for example, of 390 applications, 261 were rejected on this ground. Only 129 were accepted, whereas no applications were rejected on the grounds of no prior knowledge of HS2. Interesting statistics, particularly if you highlight that last criterion of exceptional hardship. A balance very much in favour then of your discretionary exceptional hardship application on Phase 1 being accepted. Looking at the applications which were accepted, 88% of them were within 400 metres of the route, but 98% of the rejected ones were more than 200 metres from the route. 29 applications were accepted despite not meeting all the criteria out of the total of 390. No commercial applications were accepted. 101 out of 372 residential applications were accepted, and 3 out of 14 agricultural applications were accepted. The combined effect of that was that overall a mere 104 out of 390 applications were accepted. These figures were current in 2014. If we now just put the discretionary blight scheme for HS2 in the context of formal compulsory purchase, we have a preliminary period where there was no compensation available at all. Then we have the exceptional hardship scheme. Then, once the route counts as being subject to statutory blight, we have statutory blight protection. And following the blight period, we have the formal acquisition and compensation procedures. Running alongside this, for people not on the line of the route, we have discretionary blight. Discretionary blight, once the route has been built and brought into operation 1 year later, we have the prospect of Part 1 claims under the Land Compensation Act 1973. We also have, from the start of formal acquisition and compensation procedures, the prospect of Section 10 claims under the 1965 Compulsory Purchase Act, otherwise known as McCarthy claims, where no land is required, but damage to value has been suffered as a result of the presence of the works rather than their subsequent use. When does statutory blight come into play? When the site safeguarding orders were brought into play. And that's the hybrid bill which was approved last year, which has effectively done that. So that counts as statutory blight under Schedule 13 of the Town and Country Planning Act 1990. In the Queen's Speech of 2013, May of that year, we were promised an HS2 hybrid bill which would contain the legal powers for compulsory purchase and would grant the deemed planning permission to construct and maintain the railway. Alongside that, we also had the High Speed Rail Preparation Act of 2013, which was the first proper authorisation of government expenditure, including expenditure on design and ecological surveys and other preparatory work. It required expenditure to be reported, and, in the words of the government statement which accompanied the announcement of that bill, it demonstrated Parliament's backing for cracking on with this vital project which already enjoys cross-party support. One may take that a little tongue-in-cheek, I suspect. So, the current schemes for HS2, we have one part of the route which is covered by the statutory blight procedures. That's where land is actually required and the zone has been safeguarded in respect of Phase 1. We also have a rural support zone which extends from 60 to 120 metres in rural areas where owner-occupied houses, small businesses and farms will be considered for purchase, and HS2 will buy these properties for their unblighted value plus some costs. As an alternative, it's also possible to apply for a 10% of value cash payment to stay put. There's also a homeowner payment scheme. This homeowner payment is varying anything from £7,500 to £22,500, banded according to the size of the property. This comes into effect after royal assent to the legislation. On top of that, there's a need to sell scheme, which replaces the exceptional hardship scheme for phase 1. The express purchase scheme applies in the safeguarded zone, which goes out to 60 metres since April 2014, and it provides for streamlined purchases at the unblighted value of the property, plus a 10% premium up to a maximum payment of £49,000. It was reported that 60 properties had been bought by the end of 2014 for a total purchase price of £54.2 million. As I say, that was reported by HS2 for what they had bought up at the end of December 2014. Total property purchase for HS2 up to December 2014 was reported as 60 properties under statutory blight, 132 under the exceptional hardship scheme for phase 1, 41 properties under the phase 2 exceptional hardship scheme, and a total of 233 properties with a combined value of £157.4 million. Quite a significant investment. There are other examples of discretionary blight. For example, HS2 promised the streamlined purchase scheme. We've seen how that works. It also has promised a sale and rent back scheme to offer flexibility over when to move exactly, having sold to HS2. In a period of 1 year, there were 10 judicial review hearings over the proposals for HS2, and the only one that was actually upheld was the one that related to compensation schemes. The others were all rejected by the courts, and the government had announced it was going to rerun that consultation exercise rather than challenge the judgment further. And so we get to the end of our 4 presentations on blight and compulsory purchase, and we end up with 7 questions. Are the following eligible for blight protection? Again, you might want to look at the questions, pause the presentation while you think about your answers, and then I'll tell you what they are. So, the answer. 1. Large corporate headquarters for a bank will certainly exceed the rateable value limit. 2. A cottage let on an assured tenancy. Because there isn't an owner-occupier, this will also fall foul of the blight rules. 3. Beaumont periods. Nothing to do with statutory blight at all, everything to do with potato blight. 4. A farm let under the Agricultural Holdings Act 1986. Nobody will be satisfying the requirements for owner occupation, in that case if it's a traditional annual agricultural tenancy. A small corner shop, owner occupied, very likely to be covered by the blight provisions, just need to check the rateable value limit. Mrs. Smith in her bungalow from 3 months ago, she's not lived there long enough yet, she needs to have been there 6 months. Mr. Jones, who moved out of his house 13 months ago to work abroad, leaving the empty house under the care of his brother, no, it's been empty more than 12 months, so it too falls outside the blight protection areas. So, to go back to the outcomes we set ourselves at the start of the first of these 4 presentations, we've had a look at the basis of statutory and discretionary blight under the Planning Acts, we've looked at the procedures for a statutory blight claim, and we've in particular tried to have a good look at the agricultural limitations of blight entitlement. We've prepared valuations for blight on agricultural property, or looked at the requirements for such a valuation anyway, and we've also had a look at some recent developments with discretionary blight and their wider implications, the sort of thing that would apply to HS2 and nationally significant infrastructure projects as well. I hope you found that a useful series of classes and a useful series of questions to test your own knowledge of statutory and discretionary blight as well. Thank you very much once again for your attention.